Good news. USCIS has issued a new rule to try to help immigrants who've been waiting for their work cards for too darn long. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. In this video, we're going to do a deep dive into the new rule, what it means. We're going to talk about the problem that is trying to be solved, what USCIS has done in the past to try to solve that problem, and then we're going to talk about what this new change in the extension of work cards means for immigrants who've been waiting too darn long for their employment authorizations. All right, of course, there's lots of ways to get an employment authorization document in the United States. You know, asylum seekers get them, H-4, spouses of H-1B, visa holders can get them. Lots of different ways to get an employment authorization document. And what we're talking about here is when the original employment authorization document is about to expire or has expired, and the hardship that that creates for our immigrant friends who are going through the process trying to get the ability to keep on working. Of course, the greatest way that people get an employment authorization document is through the green card process. As part of the green card process, USCIS issues a temporary employment authorization document through a form called the I-765. That's the application that you file when you apply for adjustment. And when you apply for adjustment, the goal was to let you work temporarily while the green card case was processing. So in the old days, when we would file for a green card and we'd also apply for the employment authorization document, that work card usually came in about 2 or 3 months. If you can imagine that, based on processing times now of 7, 8, 9 months, it used to come in 2 to 3 months. And when it was issued, it would be issued for 1 full year. Now, for years and years, USCIS would get those employment authorization documents processed and get the green card case approved long before that 1-year expiration date on the employment authorization document. In other words, they were always getting the green card issued before the 1-year anniversary of the employment authorization card. So this was never a problem before. But then those of you who've been following the immigration processing times have seen that green card cases have taken longer and longer and longer. And USCIS is now taking more than a year, year and a half, even 2 years to approve a green card. And what that means is that people who get that original work authorization lose it because USCIS can't get their act together and get the green card case decided. So what this means is that people are having to quit their jobs, they're losing their sources of income, and it's really producing a hardship on immigrant families. But that's the important fundamental thing that you have to understand. It's that the green card cases are taking too long. As long as green card cases are taking too long, that means the impact of an employment authorization document expiring is that much harder. Of course, if USCIS would simply do their jobs and get green card cases approved in a timely fashion, we wouldn't have to mess around at all with extending work authorization. Work authorization cards would become almost unimportant because the green card cases would have been processed in a timely fashion in the way that USCIS is supposed to do it and in the way that they have historically done it. As we've seen the delay in green card cases go on and on and on, now we see a backlog even in employment authorization documents. So not only are green card cases taking longer, employment authorization cases are taking longer, and it's really become a vicious cycle where USCIS just can't catch up. And so they have tried several things to alleviate the hardship that befalls immigrants who are in this limbo where USCIS can't approve the employment authorization and they can't approve the green card. Now, I guess we should give them some credit for admitting that they have a problem. You know, in the 12 steps, step 1 is to admit that you have a problem. So I will give USCIS some credit for admitting that they have a problem, and I will also give them credit for some of the things that they've tried to do to fix this problem. Of course, they're not fixing the underlying problem, but we've sort of beaten that horse to death. So now I will talk about the things that they've done to try to make it better. One is that they've made some employment authorization documents, some work cards, valid for 24 months instead of 12 months. So that's a good thing. USCIS has also instituted an automatic 180-day extension, which means that you can keep on working for 6 months after your employment authorization document expires. So that was supposed to solve the problem, that they added almost 6 months to the process, which means your work card is basically valid for 180 days. But that has not solved the problem either. Another thing that USCIS has tried to do to make this better is to separate out the advance parole document from the employment authorization document. So when I first started practicing immigration law, you would receive a separate advance parole document. That's the document that allows you to travel overseas. It would be on a piece of paper and it would have your picture on it. And that's what you would use to travel outside the United States with your passport. Then USCIS started making it a combo card. And for whatever reason, USCIS now believes that the combo card is part of the problem. So in an effort to try to get people to work faster, they have separated out the advance parole from the EAD. And so now we're back to getting two different documents. I saw an advance parole document on paper the other day and I sort of laughed because it had been so long since I'd seen one. I'm not entirely sure if this is a solution that actually works. I don't see how separating out employment authorization documents from advance parole makes it all go quicker because you're going through the same background check. This one's sort of a head scratcher for me. I don't really understand what they're trying to do, but if it works, it works. And if people can get to work faster, that's great. Of course, I suspect that what we'll see is a delay in advance parole. And there's some immigrants who really need that advance parole to be able to leave the United States for emergency reasons or other reasons. And so I think this is a solution that's not going to be very effective. And then recently there was a whole lot of hullabaloo when USCIS announced that they were going to allow people to pay premium processing to get their employment authorization faster. That is, you could pay $2,500 to get USCIS to do its job a little bit faster. This too was a head scratcher. I don't know why anyone would believe that this agency doesn't have the ability to do things quickly if they're saying, well, we can do it quickly only if you pay us $2,500. So I think they're all over the map. I think they're sort of running around like chickens with their heads cut off. I don't think there's a unified plan to solve these problems. I think it's become a collection of Band-Aids instead of fixing the underlying problems, which is just adjudicate the green cards faster and the rest of these problems will go away. So that brings us to the new rule. The new rule went into effect on May 4th, 2022. And what it says is that they are going to extend that automatic extension from 180 days to 540 days. Now, this sounds good. This sounds great. Like you're going to get your 1 year of work authorization when you file an I-765, and then you're going to get an automatic 540-day extension. Sounds good. So basically they're saying that employment cards are going to be basically 2.5 years instead of 1 year. And I guess that's a good thing. Now, part of me is worried because it telegraphs that they don't think they're going to be processing these employment authorization cases in 2.5 years. That's scary. The fact that they're going to take 540 days extra and add that on, this is one of those things where it sounds like they're giving you something good, but really it's telling you the fundamental problems at USCIS. This is not how I would go about doing it, but this is what they've decided to do. So for anybody who applied for an extension before May 4th, 2022, or anyone who did apply for an extension and their employment authorization expired or their 6-month extension expired, you're now going to get the ability to work with that 540-day automatic extension. All right, so who does this apply to? Well, in order to qualify, you have to have had an employment authorization document in the past. So this doesn't apply, obviously, to original filings. This is only for extensions. And your extension had to have been filed before your prior employment authorization document expired. It also has to be in the same category. So you can't be switching from one employment authorization category to another. For instance, if you're coming from an F1 on OPT and then you're getting an EAD based on marriage and a pending green card application, this extension wouldn't apply. It only applies to people that are applying for an extension in the same category. And then, of course, this extension only lasts until the case is either approved or denied. In other words, if your 765 extension request is denied, then the automatic extension would be over at that point as well. As far as the time frames, this rule applies to anyone who filed for an extension before May 4th, 2022, or anyone who files after May 4th, 2022, up until October of 2023. So in October of 2023, the rule will revert back to the 180-day extension. I do take this as a sign of hope that USCIS believes that in the next year and a half, they'll be able to fix this and right the course and get things back on track. We'll see if that happens. In my experience, when they give themselves these long timelines to fix things, they usually don't. And so this rule may get extended again, but for now, it's basically in place from May of 2022 until October of 2023. So anybody who applies for an extension in that time frame will get the automatic 540-day extension of the prior EAD that they had on file. Here's a little bummer, though. The new rule does not apply to people who are applying for an EAD extension based on DACA, the Deferred Action for Childhood Arrivals program, nor does it apply to people who are on OPT, say, for instance, a STEM extension. I'm not sure exactly why USCIS excluded these groups. These are groups of people who are hardworking and need their employment authorization just as much as everybody else. But I guess there's some political issues with DACA and some issues that they're concerned about not getting all the fees that they could get out of these poor kids who are here in the United States trying to work and trying to stay in status. But for whatever reason, USCIS has excluded those two categories of employment authorization. So keep that in mind. So what does it all mean? Well, of course, we support any effort by USCIS to make life easier for immigrants. We're always going to be applauding when USCIS takes actions like this to try to make it better. And whatever it takes to make it better, we're down with that. We're not going to ding them. We're not saying that this is like it was in the Trump administration where they sat around thinking up ways to make things harder for immigrants. But I will say that, again, it's not the silver bullet solution that we were hoping for. We think it moves the needle a little bit in favor of immigrants. I've explained to you in this video why I think that overall it's not a great solution, but we'll take it because right now that's all we got. Right now, the only relief that immigrants can get is through the administrative process. It's only President Biden and Secretary of Homeland Security Alejandro Mayorkas who can fix these things. I'm glad to see that there's a little bit of movement. I'm glad to see that people are going to be able to work a little bit faster and to keep on working, to not lose their job. This is good for Americans. It's good for the economy. It's good for immigrants. So hopefully saner heads will prevail. Hopefully they'll use this time and give themselves a little bit of relief to get back to the fundamental problem, which is fixing the green cards. We hope you found this video helpful. If you did, be sure to give us a call, 314-961-8200. You can email us, info@hackinglawpractice.com. If you don't know, we have an Immigration Answers live show. We're live 3 or 4 days a week, every week, answering as many of your immigration law-related questions as we can in an hour. Be sure to subscribe to our YouTube channel or join our Facebook group, which is called Immigrant Home, so that you get updates whenever we make videos like this one, and so that you find out when we're going live in our Immigration Answers show. Thanks a lot, and we'll see you next time.